Hello, my name is Mason Waring. I am a partner at Chisholm & Kilpatrick, and I'm joined here today with my colleague, Supervising Attorney Leah Small. We are often asked the questions, what is ERISA and how does that impact my long-term disability claim? Well, we're going to answer those two questions today. We're going to provide some background on ERISA, and then talk about how ERISA impacts long-term disability initial claims, appeals, and court litigation. So let's get started. Leah, can you provide our viewers with some background on ERISA?
Sure. So ERISA is the Employee Retirement Income Security Act of 1974, and that's a federal law that governs most employer-provided benefit plans, including long-term disability insurance. ERISA aims to protect employees from mismanaged plans and also outline some of the responsibilities that plan sponsors and plan administrators have when providing such benefit plans. For example, under ERISA, your employer is required to provide you with a copy of the plan governing documents. And those are really important as they're going to outline the type of funding of the plan, what benefits are provided under the plan, what your rights and obligations are as a claimant under the plan. So lots of important information there.
Right, and those documents are typically available from your employer. So if you have an HR department, you can ask your HR department or whoever else is responsible for administering the benefits at your work. So let's speak next about the initial claim. How does ERISA and the Department of Labor regulations impact the initial claim?
So as I mentioned, ERISA is going to outline the responsibilities of the insurance company or the other plan administrator in handling the claims, and it also outlines your rights as a claimant when you're filing a claim. But for claimants themselves, a good place to start is those plan governing documents we talked about earlier, because those are going to outline how you file a claim, potentially what sort of evidence you should submit in support of your claim, and also, most importantly, what your deadlines are in filing a claim.
And then if your claim is denied, ERISA has some deadlines and rules that apply to the appeal that you would need to file.
So if as you mentioned, if your claim is denied, filing an administrative appeal with typically the insurance company is the next step claimants are looking at. Under ERISA, you do, again, have some rights. For example, you are entitled to get a copy of the documents that the insurance company relied on or generated while they were reviewing the claim, and so you can get a copy of those and review those. And that can be a good idea when you're appealing, because that will let you see exactly what sort of evidence potentially the insurance company considered, what evidence was missing, what opinions they had that you need to respond to, things like that. Typically, in ERISA-governed claims, you have 180 days to appeal a denial or termination of your long-term disability benefits. If you miss that deadline, though, that could end up resulting in losing your rights to your benefits, because ERISA does require claimants typically to exhaust those administrative remedies in order to pursue their claims further, such as in court. Once you file your appeal, the insurance company also has deadlines they have to meet, though. They have 45 days to make a decision on your appeal, although they are allowed to take a 45-day extension if there are special circumstances that warrant that extension. And ERISA typically also limits you to the appeal stage as your last chance to submit evidence into the record. So this is a really critical stage in ERISA, because if you don't submit evidence with your appeal now, you may not be able to get it in later, and that can pose a problem down the road in court if you haven't submitted enough evidence to support your claim.
And so for that reason, the appeal stage is a great time to get an attorney involved, or at least consult an attorney to ensure that you're doing what you can to provide the evidence that you need to prove your claim. And Leah, you also mentioned obtaining a copy of your claim file. You typically do that by submitting a written request to the insurance company for a complete copy of all the documents that were collected, generated, relied upon, or not related to your claim during the claim process there. And it's really important to get that so that you can review that as you're preparing your appeal. So let's turn next to court litigation. So if your appeal is denied, it's time to go to court. Leah, can you tell us about court in an ERISA-governed long-term disability claim?
Sure. So a good place to start, again, as with claims and appeals, is reading those plan governing documents. Many plans, sort of long-term disability plans, have what we call a contractual limitation period, which is the deadline that you have to file suit in court by. And if you miss that deadline provided in your plan, again, you could lose your rights to pursue your claims further. Some plans don't have a deadline specified in the documents themselves, and in those cases, typically state law, state statute of limitations are what's going to govern your deadline for filing suit in court. But it's really important that you understand those deadlines and make sure you're meeting those deadlines. If your claim was filed after April of 2018, under ERISA, insurance companies are required to notify you of what that planned deadline is to file suit in their appeal denial letter. But again, it's important you read that carefully, understand it, and make sure you meet that deadline. ERISA litigation in court looks a lot different than what people typically think of as a typical civil litigation or trial. Oftentimes, there are not juries, and as we know before, you typically can't submit new evidence in court. So you're going to be limited largely to that record that was built before the insurance company during the administrative appeal process. It's also possible that the court will give deference to the insurance company's decision, which means they're not determining whether they were right or wrong to deny benefits, but just whether they had a reasonable basis to deny. So again, there's a lot of kind of weird things about ERISA litigation, and so if you don't have one already, it's a really good idea at that stage to get an attorney involved to assist you to make sure no deadlines are missed and everything is done as it should be.
Well, thanks, Leah. That's a good brief overview. There's certainly more we could talk about here. It's not necessarily a simple subject. We work with it every day. So if you have questions about ERISA, about your long-term disability claim, please reach out to us to see if we could help. It costs nothing to speak with us to see if we can help. You can reach us via our website at cck-law.com. You can also call us at 401-331-6300. If there are other topics you'd like to hear us talk about, please leave a comment. Don't forget to subscribe to our YouTube channel and like us on social media. Thank you very much.